In this video, we will cover how the UCC limits the freedom of contract when one party, typically the seller, attempts to disclaim any warranties made as to the goods that she sells. First, why would a seller want to include terms in the party's agreement disclaiming warranties? The answer to this may seem obvious. Warranties create potential liability for sellers. Liability in the event the warranty is breached, the facts warranted are untrue. So naturally, sellers will often want to limit their exposure to potential warranty liability. Sellers can limit their exposure to warranty liability in one of two ways. Most obviously, a seller can try to limit the scope of the warranties that she makes to the buyer in the first place. Stated differently, a seller can try to disclaim warranties so that the warranties are excluded from the party's contract. That is what we'll cover in this video. Alternatively, or in addition, a seller can try to limit the scope of remedies available to the buyer in the event the seller's warranties are breached. So the seller makes a warranty as part of the party's contract, but the consequences for the breach of that warranty, that is, the buyer's remedies, are limited by the contract. That is what we will cover in the next video. So let's start with warranty disclaimers. How can a seller disclaim warranties regarding the goods that she sells to the buyer? The answer is it depends on the type of warranty that the seller wishes to disclaim. Recall that in our original discussion of warranties, we distinguish between express warranties and implied warranties, and we will look at disclaimers of each in turn, starting with express warranties. Before we ask how express warranties may be disclaimed, however, it's helpful to first review how is an express warranty created. Press pause now and think about it. See if you remember. The answer to this question is provided in section 313 of Article 2. Recall, any time a seller makes an affirmation of fact or promise about the goods, or provides the buyer a description, sample, or model of the goods, which forms a part of the basis of the party's bargain, then the seller makes an express warranty to the buyer, that is a contractual promise. The goods will conform to the fact, promise, description, sample, or model that the seller has provided. But we noted also in that context that it is important to distinguish express warranties from mere puffery, statements of value, opinion, or praise, which Section 313 affirmatively states do not create warranty liability for the seller. With that bonus review out of the way, we can now turn to the question of warranty disclaimers, how an express warranty may be disclaimed. How can you disclaim express warranties? Section 316, subsection 1 of Article 2 provides the answer, which is that you basically can't. The rationale for this is described in Comment 1 to Section 316, which suggests that there is something inherently suspicious about a seller that makes an express warranty and then tries to disclaim it in a written agreement with the buyer. Specifically, the rationale is that if the seller has made an affirmation of fact or promise about the goods, or provided the buyer a description, sample, or model of the goods, and that truly formed a part of the basis of the party's bargain, then that should be something that is hard for the seller to disclaim. It should be hard in order to protect buyers from unscrupulous sellers. Now, that's not exactly what subsection 1 of 316 says, but that is the gist of it. What does subsection 1 of 316 actually say? It reads, words or conduct relevant to the creation of an express warranty, and words or conduct tending to negate or limit a warranty, shall be construed wherever reasonable as consistent with each other. So, whenever it is reasonable to do so, language or conduct creating an express warranty must be interpreted to be consistent with any language or conduct that would negate, limit, or disclaim the express warranty. But to the extent such an interpretation is not reasonable, then the negation or limitation is inoperative, legally invalid. Such language is not given effect as a disclaimer. So essentially, the only way to disclaim an express warranty is for the seller to not make one in the first place. Because once an express warranty is made, it cannot be disclaimed by the terms of the agreement. Such a disclaimer term, attempting to disclaim a warranty, is inoperative. To illustrate the import of subsection 1, let's consider a couple of examples using my trusty old beat-up car that I've been trying to offload on you all semester. Let's say I'm trying to sell you my car, and to pique your interest, I say to you that the car is free of any defects. Later in the conversation, I also mention that the car is a used car, so of course it has normal wear and tear. Based on our conversation, you decide to buy my car. Under these facts, a court could give effect to both of my statements by interpreting my second statement as a limitation on the extent of the warranty made by my first statement. It would be reasonable to construe my statements to mean that I am warranting that the car has no defects except for normal wear and tear that all used cars of this type might have. Now let's assume that to pique your interest, I instead say that this car gets 40 miles per gallon. Impressed by the fuel efficiency, you decide to buy it. But I first have you sign a written sales contract, which includes a blanket disclaimer of all express warranties. Now it's impossible to harmonize the express warranty I made to you about the gas mileage with the broad statement in our written agreement purporting to disclaim all express warranties. Under subsection 1 of 316, the court would negate the disclaimer in the written agreement. It would be inoperative. That is how subsection 1 of 316 would work in theory. But note, subsection 1 is subject to a very important limitation, the parole evidence rule, codified in section 202 of Article 2. This is a rule that we will cover in next week's module, a rule that you might remember from your study of the common law of contracts, a rule that says that when parties reduce their agreement to writing, and that writing purports to disclaim any warranties, any extrinsic evidence, that is, evidence beyond the writing, that would show that an express warranty was in fact made is excluded. This previews the importance of a merger or integration clause in a written agreement. We will come back to the parole evidence rule and disclaimers of express warranties in next week's module. For now, you might just note that I can be a sneaky seller. With express warranties out of the way, let's now consider implied warranties. How can a seller disclaim an implied warranty that might otherwise be implied into the party's contract? Here it's helpful to start with a thought question first. Why should the law even allow disclaimers of implied warranties of merchantability or fitness? After all, the implied warranties are different than express warranties. In the context of implied warranties, the law is implying the existence of the warranty because we think the implied warranties give effect to the party's reasonable expectations, give effect to what the parties likely expected. With respect to the implied warranty of merchantability, that reasonable expectation is that if the seller is a merchant of goods of that kind, then the goods being sold to the buyer will be of at least average quality. With respect to the implied warranty of fitness, that reasonable expectation is that if the seller knew that the buyer had a particular purpose for the goods and was relying on the seller to pick out suitable goods, then the goods sold would be fit to the buyer's peculiar purposes. But unlike express warranties, implied warranties are implied into the party's contract. They're implied, meaning they're not something the parties expressly agreed upon. Therefore, as we noted in our discussion of implied warranties, the implied warranties are more like gap filler terms, default rules of the UCC that are not mandatory contract terms. Unlike express warranties, it is possible to disclaim the implied warranties under the UCC. But because the implied warranties reflect what we think is the likely expectation of the parties, the law imposes certain additional burdens to effectively disclaim the implied warranties, burdens that require the parties to make it clear they did not intend to be bound to the implied warranties. So what does Article 2 actually require to waive the implied warranties? Unfortunately, the answer is both complex and nuanced, but we can start with subsection 2 of 316, which states the general rule. To exclude or modify the implied warranty of merchantability, or any part of it, the language must mention merchantability and in the case of a writing must be conspicuous. So to exclude or disclaim merchantability, subsection 2 requires two things. First, the disclaimer must use certain magic words. It must specifically mention the word merchantability. Second, the disclaimer must be conspicuous, but only if the disclaimer is in writing. So an effective disclaimer of merchantability need not be in writing. A written disclaimer is not required to exclude the implied warranty of merchantability. Stated differently, an effective disclaimer may be made orally. And if you disclaim it orally, you just need to say it. You don't need to shout it. The conspicuousness requirement does not apply to an oral disclaimer of the implied warranty of merchantability. But if the disclaimer is made in writing, then the disclaimer term must itself be conspicuous. Note, conspicuous is itself a defined term under the UCC. Is defined in Article 1, Section 201b10, and it's defined in a way that you might suspect. A term is conspicuous if the term is presented in such a way that a reasonable person ought to have noticed it. So, for example, a term might be conspicuous if it's presented in all caps or an all bold typeface, and it's certainly not conspicuous if it's buried in a maze of fine print. That takes care of merchantability. What about the implied warranty of fitness? Going back to subsection 2 of 316, it reads, to exclude or modify any implied warranty of fitness, the exclusion must be by a writing and conspicuous. So, to keep things nice and complicated, Article 2 provides for a similar but different rule. To exclude or disclaim fitness, subsection 2 requires two things. First, the disclaimer term must be written, and second, the disclaimer term must be conspicuous. Note the differences here between a valid disclaimer of merchantability versus fitness. For fitness, no oral disclaimer is allowed. The disclaimer must be in writing. Second, the disclaimer may be accomplished by general language. There are no magic words required to disclaim fitness. There's no need to specifically mention fitness for a particular purpose. General language like, there are no warranties which extend beyond the description hereof will suffice. Subsection 2 of 316 states the general rule about disclaimers for implied warranties, what I like to call the gold standard for what a valid disclaimer would require. Subsection 3 states the exceptions, other narrow specific circumstances where the implied warranties may be disclaimed. And the common theme in each situation under subsection 3 is that each situation is one where the circumstances surrounding the transaction are themselves sufficient to call to the buyer's attention the fact that no implied warranties are being made or that certain warranties are being excluded. These are exceptions to the general rule articulated in subsection 2, so do not overestimate the applicability of the exceptions in subsection 3. So what does subsection 3 say? Well, it includes 3 exceptions. Let's start with 3a, which says an agreement does not need to use the magic language noted in subsection 2. If the agreement does use other similar language, which makes it plain under the circumstances that all implied warranties are being disclaimed. For example, language like the goods are being sold as is or with all faults. Whatever the language, 3a says the language must make it plain that there is no implied warranty. What other language might suffice beyond as is or with all faults? Courts have been very reluctant to accept any other language beyond what the statute prescribes. Again, do not overestimate the scope of 3a. Note that subsection 3a does not apply where the circumstances indicate otherwise. Thus, unlike subsection 2, subsection 3a leaves courts room to exercise discretion to hold that an attempted disclaimer is invalid, even if the seller uses language like as is, where the court thinks that the buyer did not reasonably understand that she was purchasing goods that may be unusable, unmerchantable, below the reasonable expectations of the average ordinary buyer. So, for example, in a sale where the buyer is an ordinary consumer might understand that as is means as is, but might not fully appreciate that as is means that the product may not even fit for the ordinary purposes for which that product is used. Moreover, note that subsection 3a does not eliminate the requirements of writing and conspicuousness that apply under subsection 2. And most courts have held that even where a seller relies on subsection 3a to disclaim an implied warranty using language other than what is required by subsection 2, the seller's disclaimer, to be valid, must still satisfy the writing and conspicuousness requirements of subsection 2. The second exception to subsection 2 is stated in subsection 3b, which says that where the buyer had the opportunity to fully examine the goods before entering into the contract, then there is no implied warranty as to any defect that such an examination would have revealed. Note again how narrow this exception is. It does not apply where the buyer inspects the goods after entering into the contract. It only applies where before entering into the contract, the buyer had an opportunity to examine the goods. Likewise, it does not apply where the defect was one that was not reasonably detectable upon inspection. Implied warranties still apply to any defects that were not reasonably ascertainable by such an inspection. The final exception to subsection 2 appears in subsection 3c, which simply recognizes that course of performance, course of dealings, or usage of trade might provide other circumstances where it is clear to the buyer that there are no warranties being made with respect to the goods. One final note before we conclude our discussion of disclaimers of any warranties, which is that compliance with 316 is always necessary to validly disclaim a warranty. But compliance with 316 alone does not mean that the disclaimer will be valid and enforceable. The buyer may still challenge a disclaimer as unconscionable and therefore unenforceable. Stated differently, compliance with 316 is necessary but not sufficient. So that concludes our look at warranty disclaimers and the limits that Article 2 places on the ability of parties, mainly the seller, to disclaim warranties. And as we saw, the limits are different depending on the nature of the warranty, whether express or implied. In the next video, we will look at one final area where Article 2 limits the freedom of contract for the sale of goods, specifically where the parties' agreement purports to opt out of the default remedies available in the event of a breach.